First, following the consolidation of the cases, your position was that the current register could not be used. The court essentially agreed with you. Your initial reaction to the decision of the court?
I think it's very welcome. For me, it can only advance democracy in the country, in the sense that the very sense of democracy, the protection of the right to vote, and the right to the people to elect their representatives, to elect their president, in accordance with the hallowed principle of one man, one vote. And I sought to indicate at the last agenda that indeed the voters register has been shown to be over-bloated, and it has been so since 2012, and it was so again in 2016. It was also it is so presently. So it has been so since 2012. And if you look at 2012, the declaration of results, the number of registered voters, as declared by the Electoral Commission, was about 14.1 million people. But the total number of Ghanaians over 18 years was, as per the statistics of the Ghana Statistical Service, 13.7 million. So the very obvious question one ought to ask is, how can the number of Ghanaians aged 18 and above, who I consider to be the registrable population, be less than the number of total number of registered voters? That is incongruous. It cannot be. And the same pertained in 2016. The number of registered voters was about 15.7. Yet, Statistical Service indicates that the total number of Ghanaians aged 18 and above is about 15.2 million. And you remember that the NDC also was making a point in court that there is supposed to be about 18 million people on the voters register. That was unsubstantiated and totally baseless, because the evidence for the Statistical Service, which I furnished the court, indicates that the total number of Ghanaians aged 18 and above is 16.6 million people. So where from that figure? They just threw it up in the air without backing it up with evidence, and that's what the people of Ghana were made to believe. And so I think that the court ruling is very good. It protects the right of the Ghanaian to vote, in the sense that it shows that clearly it is intended to ensure that only Ghanaians who are qualified to vote indeed register to vote.
In terms of the ratio of the court, it affirmed the independence of the EC once it's not acting contrary to law, and again gave orders as to compiling the register in accordance with CI 126. I'm sure you have seen what the NDC's General Secretary has been saying. Are you surprised with the interpretation that has been put on the decision of the court, and what is the AG's position on the decision of the court? I'm
totally amazed at the ridiculous interpretation that has been placed on the court ruling by the NDC, especially NDC's General Secretary. I mean, clearly, it's only a person who perhaps did not have an understanding of what the court said today who could make such a conclusion. It is quite clear. They have the ruling of the court before me, and you have to just match it against the specific reliefs that were sought by the NDC. And you see that clearly in terms of the substantive reliefs, they were all dismissed. The substantive reliefs were relief 4, which was a declaration that upon a true and proper interpretation of the provisions of the Constitution, particularly Article 42 of the Constitution, all existing voter ID cards duly issued by the second defendant, the Electoral Commission, to registered voters are valid. That is the NDC's claim. Now, what did the court say? The court stated relief 4 dismissed. Relief 4 was dismissed categorically and expressly. Then you move on to relief 5, which was also one of the reliefs bordering on the use of the voter ID card to register. It says a declaration that upon a true and proper interpretation of the Constitution, specifically Article 42, the second defendant's purported amendment to Regulation 1. That is the new regulation that NDC was complaining about, Regulation 1, Sub-Regulation 3 of CI 91, through the Public Elections Registration of Voters Regulations 2020, to exclude voter ID cards as proof of identification to enable a person to apply for registration as a voter is unconstitutional. Same was also dismissed by the court. Relief 5 dismissed. Then relief 6, a declaration that the second defendant in purporting to exercise his powers pursuant to Article 51 of the Constitution to exclude the existing voter ID cards from the document required as proof of identification to enable a person register as a voter without any justification is arbitrary. Same was also dismissed. Relief 6 is dismissed. Then the court proceeded to reiterate their decisions in the Abu Ramadan number 2, that indeed where the Electoral Commission has a discretion to exercise and there are options available to it, no person can question any choice that the Electoral Commission makes. And the court proceeded again to dismiss Relief 7. Relief 7 was that a declaration that upon a true and proper interpretation of the Constitution, especially Article 42, proof of identification for registration as a voter should not be limited by the provisions of the Public Elections for Registration of Voters Amendment Regulations. Again, same was dismissed, and they said subject to CI 126. CI 126 is what has been enacted by the Electoral Commission. So clearly, all the substantive relief sought by the NDC were categorically and expressly dismissed. There's no ambiguity at all. If there's any lack of clarity, perhaps lack of clarity only emanates from the poor understanding of some sessions of the NDC who were in court today.
And in terms of the jubilation that they engaged in, which was obviously problematic, it started from the bit about the two reliefs that were granted. The first that made the point that, I mean, you have the right to vote and it cannot be taken from you capriciously. And the second being that it accrues to you once you are issued with a card. Some interpret that to mean that it will mean that we have to make some amendments to CI 126 since those people have already been issued with cards and it has accrued to them.
That is totally ludicrous and legally untenable. Indeed, the two reliefs that were granted by the court, as far as I'm concerned, amounted to mere commentary on the provisions of the Constitution. The two reliefs did not add anything at all to the NDC case at all. They were a clear statement of what the Constitution itself has stated. Because if you seek a relief that a declaration upon a true and proper interpretation of the Constitution, specifically Article 51, read conjointly with Article 42 of the Constitution, the power of the second defendant to compile and review the voters' register must be exercised subject to respect for the right to vote. What have we sought? Nothing at all. We are only stating what the Constitution impliedly and explicitly state, that indeed the right to vote must be respected. Yes, so the court is granted. So what? It's empty. It's nothing. Then you go to the other relief that was granted. A declaration that upon a true and proper interpretation of the provisions of the Constitution, particularly Article 42, upon registration of an issuance of voter identification card to a person, that person has an accrued right to vote, which cannot be divested in an arbitrary and capricious manner. Again, that's what the Constitution implies and expects. And what did the court say? Relief 3, no, sorry. So the court stated that relief 3, the relief is granted subject to the voter registration card issued to an eligible voter under the prevailing constitutional instrument CI 126. So it's clearly that yes, we even agree with your contentions, which is, as I indicated, what the Constitution expects and implies. But it says subject to the new regulation CI 126. So the NDC went to court, they had their faces badly bruised, and that is it. I think they ought to face the music. They ought not to play any tricks on the minds of the people. All the statements by the General Secretary were totally misleading and unwarranted. And for me, it is most deplorable because he's actually seeking to scandalize the court. You cannot go and then make or deliberately misinterpret what the court said when you were there. And clearly you can read.
Do you agree that the court should take a serious view to that kind of commentary?
These are things that, I mean, I would not even pursue, ignore it. I think that people do not take him seriously, and I do not think that it should be taken seriously. Clearly, it is what he said is rebutted by the plain words of the court's ruling, set out in black and white on paper.
The other case also, which was the Techibansin one, that one had a number of reliefs, yes. About 8 of them, also introducing new elements, including the birth certificate as well.
Good. So the denial of all the reliefs in the Techibansin case reinforces the point that indeed the NDC's reliefs were substantively and essentially dismissed. Why do I say so? Because the Techibansin case had clear reliefs. Those, as far as I'm concerned, were even reliefs that properly ought to be filed, because the lawyer in that case went straight to the point, unlike the lawyer for the NDC who sought to make commentary on provisions of the Constitution, a declaration that if you deny a person's right to vote is unconstitutional. It's something that everybody knows to answer. But the Techibansin case explicitly sought a declaration that the use of the old ID card was unconstitutional, and also proceeded to say that the use of the birth certificate, a denial of the use of the birth certificate was also unconstitutional. And the court dismissed all the reliefs. So how could the NDC jubilate on account of the fact that, on account of an allegation that their reliefs had been granted. And the same court will dismiss all the reliefs that were sought by Techi Benson. So, for me, even the dismissal of the entire relief sought by Techi Benson clearly throws light on the point that all the substantive reliefs that were sought by the NDC, which were essentially the same as Techi Benson, were also dismissed. At least one not in that at all. So, birth certificate cannot be used. The old voter ID card cannot be used. That's the effect of it. And the Supreme Court proceeded to actually admonish Ghanaians to comply with the regulations that had been enacted by the Electoral Commission. The Supreme Court made consequential orders and says, in exercise of the powers conferred on us under Article 2 of the Constitution, we hereby make the following orders. And orders made by the Supreme Court under Article 2, Clause 2 of the Constitution are binding on all and they have to be complied with. No person can elect to disobey these orders. The Supreme Court enjoined all of us, says it is hereby ordered that all stakeholders and the Ghanaian eligible voters are directed to comply with Articles 42 and 45 of the Constitution and the Public Elections Regulations CI 126 as regulated by the Electoral Commission, i.e. the second defendant in so-and-so suit and the first defendant in so-and-so suit, in carrying the constitutional mandate to compilation for a new register. So the Supreme Court, out of abundance of caution, ordered all Ghanaians and all stakeholders to ensure that they comply with CI 126. Then, lastly, the court also made an order prohibiting the continuance of all suits pending at that court. You will recall that there had been some other suit filed in the High Court. The Supreme Court, in exercise of its powers as the highest court of the land, made an order totally prohibiting the continuation or continuance of those suits. So all those suits are stayed permanently and forever. This is the final judgment of the court on the issue in question, and it must be complied with.
I thought it was more of asking them to abide by that directive, especially with that application, because you know that is for a judicial review that has been filed at the High Court by the Ashaman MP and Esnogbe.
Yes, so it says by this decision, the Electoral Commission, second defendant, is hereby directed to commence the compulsory voter registration as scheduled. Then by these decisions as well, they proceeded that any court in which same or similar action is pending or yet to be filed shall apply the decision rendered by the Supreme Court in these cases. So no court has the option of electing whether to comply or obey this ruling. The Supreme Court has ordered in the exercise of its powers over all lower courts in the country that this decision is a final decision on the matter and must be complied with by the court.
We know they had filed for an injunction which they are supposed to move on Monday. So it means that Monday they will have to go for that. You have to go and argue that injunction before the court and ask them to abide by the decision of the Apex Court, or it operates automatically. They are not going to have a hearing at all.
Yeah, so this decision will be brought to the attention of the High Court, and the High Court will make an order accordingly, dismissing, in essence, all the reliefs sought. All the reliefs sought are also in the nature of the reliefs that, or similar to the reliefs that were being claimed in the Supreme Court. So the court would not have to hear an injunction and then come back and hear the substantive suit. The presiding judge would definitely, in accordance with this ruling, proceed to issue the necessary orders, which will be on all fours as the instant action.
By going for a judicial review, is it not fair that they allow the courts to just take a look at the process leading to the decision to compile the register, which is what normally judicial review looks at, as against the interpretation and enforcement which has been carried out by the Supreme Court?
Now, the Supreme Court under Article 129 of the Constitution has the power to exercise all powers vested in any court at all. That we call it the residual jurisdiction, the residual power of the Supreme Court. They can exercise all powers that are lawfully vested in any court or tribunal in the country. So the Supreme Court, in exercise of the powers conferred on it by the Constitution under Article 129, has made these consequential orders. And all courts are supposed to comply. I think the essence is quite clear, that there ought to be order in the administration of justice. There cannot be a situation where the Supreme Court has taken its time to adjudicate on this matter, made orders which are binding on the NDC and all citizens, and then another citizen will be prosecuting another matter in the lower court. So for the sake of ensuring order and an efficient administration of justice, the Supreme Court has exercised its powers under Article 129 and made these orders. And all courts will be required to comply.
One thing that came up in the course of this proceeding has to do with the amicus application. You had argued that they were coming in not to add anything new to the court. Do you think, per what the court has concluded, that indeed looking back at the brief that they had intended to submit, the court would have determined differently if it had allowed that amicus to go in?
Oh, definitely not. I mean, I took a very serious look at the amicus brief because indeed I realized that they had sought to attack the submissions that I had filed. And so indeed, when the lawyer got up in court to say that he had not read the submissions, the first point I made was to point out to the court that he was not being candid to the court. So first and foremost, you find a person who is not a party to the case coming into by way of a third-party intervention who is not even candid with the court. I think that that's very deplorable. So, and then you see that in his submissions, virtually, what was he bringing? Nothing at all, but just the same as the submissions that had been filed by the NDC and Techibansen. So really all he was seeking to do is to make multiplicity of arguments in respect to the same issue. And that is nothing new. Even if you look at the value of the amicus brief, I made the point that there are only two cases that were cited in the amicus brief. There's a common law tradition. There's a tradition that thrives on the passage of statutes and the decisions made by superior courts of judicature. Indeed, as specific subject matter an issue, there are many cases that could be referred to. The amicus brief had only two cases, as a matter of fact, and those were the Abu Ramadan case as well as the election petition case, which had all been examined. Then also, you would notice that the amicus, if you examine further, you realize that even the basis on which they were coming were even flawed. The amicus indicated that the number of foreigners in Ghana was 350,000. That clearly was wrong because it flew in the face of the evidence that I had presented to the court by the Statistical Service, showing that as of now, June 2020, there are about 800,000 foreigners in Ghana. So really, what are they bringing? So the factual basis on which they were coming were flawed. The legal bases were empty and hollow, and therefore they're not going to add anything new. All the points we're seeking to argue had already been canvassed by the parties in the matter. And I think in the interest of expediting, I think that perhaps one motive maybe was to delay. Because if the amicus brief had been admitted by the court, then the court would have also, definitely in accordance with the rules of natural justice, given us the opportunity of filing submissions in response to the same. This is a case where the exercise is supposed to be undertaken next week, and perhaps was just a way of preventing the hearing. And I think the court was justified in dismissing the attempt to enter an amicus brief in the matter.
In terms of the interaction the justices had with the lawyer who moved that particular motion, even though the holding was that it was not supported by law, their commentary now is being suggested that the questions of the neutrality had created the impression that to be an amicus you must not have an interest in the matter in terms of direct position on it.
No, but we also ought to, as I just kept emphasizing on candor, the candor of the parties, the amicus itself. It's a matter of public record. It managed stiff resistance to this process. They first started with challenges to the procurement processes and what have you. And when those were defeated, they started arguing on the same lines as the NDC. The alleged lack of power in the Electoral Commission to undertake the exercise, and the alleged irregularity or unconstitutionality of the exclusion of the old voter ID card. So really, their position in the matter has been made quite clear and all that. And the very fundamental basis of an amicus is that the person is a friend of the court, a neutral person, usually. A neutral person who seeks to bring some important matter of law and some matter of fact or value to the attention of the court. But where the person has shown his colors clearly as having been opposed to procurement processes, is advocating that one party should have won the bid instead of another, also advocating that the EC does not have the power, and then all of a sudden barges in as an amicus. I think that it shows a lack of bona fide.
So you think neutrality matters in such applications?
Totally, because that is one of the fundamental principles of common law, that the person who is coming is disinterested, and the person is merely interested in advancing either the rule of law or the fundamental principles of law in issuing the matter. And the person also has in his possession some very important issues of law that he or she wants to bring to the attention of the court.
When we interact with ordinary voters, I mean,
I think as for the allegations, about the lawyers' lack of preparation, I would not want to comment on it at all. The lawyers' lack of preparation, whatever, it's a matter that I would not want to comment because it involves a professional colleague.
In terms of the bit relating to the voters that have to now turn up to register, I mean, there are some who hold the view that you argued law, but in terms of their rights to it's unfair that through no fault of theirs, they queued to carry out an exercise, they got onto the register. In all your arguments, there was no point that you said that, I mean, someone got onto the register through his own actions, that he got himself registered. At least an official registered him. And so why must they now bear the brunt of a failure by the AC to obey laws to now go out there in a period of COVID and risk getting infected to carry out the registration?
Right. I think it's the NDC that we must actually castigate as having come to court without any evidence at all. As I said, they threw up evidence, allegations in the air without supporting it at all. The first allegation that they made was that there were voters who were likely to be disenfranchised.